Hi, everybody, and welcome to day number 5. Day number 5 of Cyberweek number 23. 23 years. My name is Noam Ebner. I'm from Creighton University. Our online platform, adrhub.com, used to host Cyberweek in the 20-teens. The conference has since moved on to other platforms and finally landed at odr.info, but somehow the organizing committee got stuck with me. So I'm here to welcome all of you on behalf of the organizing committee, Leah Wing, Dan Rainey, and Colin Rule. On behalf of NCTDR, the National Center for Technology and Dispute Resolution, of which I'm a fellow. Ethan Catch is a director of the center. I see that he's here. Welcome, Ethan. And we are organizing this conference. And we are so happy to have you all with us here. Speaking for myself, I know that Cyberweek has always been the most amazing opportunity to just reach out and connect with all of the people doing anything in the ODR field, whether this is your first Cyberweek or your 20th Cyberweek. Everybody who's doing anything in the ODR field is right here. I think the faces we see in this panel already is a very good example of that. And case in point, I'm here to introduce briefly two people who have done a lot. And I'm not going to share all they have done. I was at a session a couple of days ago in which Colin Rule introduced both of you, and just the introductions took around 5 minutes because of all of what you have done. So I will just say for my point that Ben Davis was one of the very first voices I heard walking into my own first Cyberweek, I don't know, 15, 18 years ago. And has remained a constant voice in the ODR field before that and since. Katherine Simpson, an international expert in international arbitration and beyond. And I'm going to invite both of you to add on any elements of self-introduction that you'd like to add that you might feel are helpful in context to sort of set the stage for where you are coming from. As you approach this very interesting and somewhat disturbing topic of technology, of creepy AI, of Algowrongs, I'm going to turn it over to you. What do all those somewhat ominous things mean?
So I am going to start trying to learn from what Noam has done. And Noam, thank you very much for being our guide today. I'm doing the old screen share thing here to put up my little PowerPoint that I hope will help with us at the beginning. I really appreciate everybody for being here. And let me get over to the screen share space that I want, which I should be at here. And if I'm lucky, yes, the PowerPoint will come up, and it looks like it's coming up a little slowly here, but there we go. There are only 6 slides, so it's a quick one to go through, and I will start the slideshow now. Can everybody see this and hear me? Please let me know.
Yes, we can.
Okay, great. Oh, excuse me. I'm sorry. So I wanted to start out by, so my title is Creepshow, appropriately enough around Halloween, and talking about something called lesser and greater pathological technologies. Now, this idea of pathological technologies kind of popped into my head a couple nights ago, and as a way of describing what I was going to talk about. It's a vessel that the definitional part I'm still working on, but one of the things I was pleased to hear a couple of days ago, was that Leah Wing said she'd never heard that terminology before. And I hadn't yet Googled it, so it was encouraging to me that it might be something new. Well, it turns out that actually the idea of pathological technology is actually written about in a book. And the book is called Monsters: The Hindenburg Disaster and the Birth of Pathological Technology. And so if you Google pathological technologies, you can see that and a few other places talking about this idea of pathological technology. So it encourages me also to say that there are other people who have looked at technology and wondered when technology was possibly pathological. To help, I try in my head have a technological continuum. I'll call one at the end of it technology and all the manifestations that we see along the way. And then as you go along, there could be sort of lesser pathological technology, which would be things that you can surmount and deal with, but they are kind of like creepy. And then there's greater pathological technology where the creep level gets really, really, really high, going up to the level of tricknology. Tricknology is not my term. It's a term that one of the Central Park 5 defendants who ultimately were acquitted of the cases that they were in. He's now a doctor, I believe, of sociology. He came to speak at Toledo, and he used that term when somebody asked him a question about technology, saying, "Oh, you mean tricknology?" So that really got me going too, as a term for looking sort of a little askance, or at least healthily skeptically at different types of technology, rather than being sort of in a rah-rah mode on it. And so it's taking a sober look. So let's think about lesser pathological technology. I'll talk about a couple here, and I will throw it to Katie if she has some lesser she wants to speak about, or some greater as we go along, okay? So here's a lesser pathological technology in my personal view. Bear with me. I started to get on my computer this Microsoft Viva, okay, which sends me every morning sort of a quick search of whatever email came into that particular account, and usually focuses on, quote unquote, the action item in that Vita, in that email. I found this really creepy, and I immediately unsubscribed from it. And guess what? The next day it kept coming back, and it just keeps coming back. And no matter how many times I unsubscribe, it did say, "Oh, I'm sorry you're unsubscribing," but it kicked me back in again. Now, why do I think this is a little pathological? Because I suggest it's maybe some kind of insidious surveillance technology, which is sort of like, maybe there's AI that decides what is the operative phrase in your email, and then that goes somewhere, and that could be gathered into a thing to see about, well, did I respond to that operative part or not? In due course, that would be looked at by somebody down the road. This is almost kind of like the keystroke and verification that could happen at some points in times in some companies to see if people are working or not working. And I just found it creepy. So I just want to put that out. Second one I have is Amazon's checkout customer service. I discussed this in the chapter in the international, the new book out that we've been talking about this week on international commercial, on online dispute resolution, that Daniel and Ethan and Mohammed have edited, where I just talk about a weird situation where I was checking out, and the way the Amazon thing works is, I think when you get to the checkout thing, you get the orange button to push, and I kept getting the light orange button because the gift card I was using didn't seem to be working. So I had to go and call Amazon's people to find out about it. The problem was that there wasn't a credit card attached to the gift card. So that was already something to get my credit card number. And plus it was a gift card where they were doing some kind of sharing with my wife on it in a way that I hadn't shared my Amazon account with my wife at that time. Nothing against my wife, but it was just something that I hadn't done. And so I was kind of weirded that they decided to share us already. And then that I had to call the customer service to solve my problem of reversing a particular charge and then getting a payment done. It turned out that the orange button came on once I put my credit card number in, at which point I found that I think it was a $90 gift card wasn't enough because there were taxes of $2.40 or something. That's why I got the orange card. So now it worked and all that, but I don't know if that $2.15 of alleged taxes is actually $2.50 of actual taxes. I can't know that. All I know is that the system kind of made me, in a very seductive way, put in my credit card information, which now sits with Amazon. I guess I can remove it somehow, maybe by calling somebody. I found that creepy. On Venmo and PayPal, there's a couple ones I use. They're basically no call center text customer service, at least in my experience. Now, I don't have a problem with doing no call center text customer service. In fact, for the most part, I found both at Venmo and PayPal that they've been really, really helpful very quickly in solving whatever problem I had. Because maybe also I type quickly too. But if you're not particularly a typist type, or you're a little creeped out by having to type things in about whatever your particular problem is and wondering where it went in the world, you know, you kind of like, gee, I'd like to talk to somebody at a call center of some kind and see what could happen there. Beyond that, then we go, and so that's a little creepy. Another one is if you go to the IRS, you of course put the voicemail, and you get the voicemail with various lists that go on forever with regards to various topics that are there. And finally, when you want to speak to a representative, then, you know, you're kind of put on hold from I've seen people who have been on hold for an hour and a half. I've heard in other settings, obviously, that the hold is much shorter. For example, when I use pods, generally the hold there is they tell you how long it's going to be, like a minute, and you're onto it. There is that alternative that some companies have where they can call you back. I've had that with utilities and all that. I think that that is a nice solution to the problem of you hanging on the phone. But one of the things about the time that this takes with regards to actually speaking with somebody is the decision on how many people in the call center and who's in the call center. The size of the call center is related to the number of calls they're getting, right? So, you know, if you have a small call center, guess what? The wait times will be much longer. But if you have a large call center, then the wait times will be shorter, but your costs of paying those folks at the call center, whether you're doing it domestically or outsourcing to Poland or India or someplace else, will be better, will be higher there. So this idea of the sort of wait times with regards to when you don't want to do it by text, when you don't want to use the website, when you want to talk with actually a human being about what your problem is something that can be creepy. Another one, of course, is our old friend Siri, who I love. One of the things that's fun to do is to ask Siri if they work for the NSA or CIA and listen to the response. The response is really excellent. It suggests that the people who created Siri really thought about this and came up with a great one. The creepiest thing I ever had happen with Siri was I was giving a speech on big data once, and I gave that speech. I think it was 20 minutes to speak, so I told Siri to set timer for 20 minutes and then started my speech. Well, I happened to finish up after all this talking about big data and stuff like that and security and all. After I finished about 15, 16 minutes in to go to questions, I told Siri, turn off the timer, at which point, like you could not have ever dreamed in front of about 100 people at the Florida Bar Association, Siri said, I'm sorry, Ben, I can't do that, okay? So it was like, whoa, what's going on with Siri there? So those are some like lesser pathological technologies I'll throw out there. Katie, would you have some that you'd like to point out too?
You know, in the professional context, I think about Dropbox and Google Drive. Not really because of they get a little bit creepy because of the information that they collect. Not so much because of the service that they provide. I think perhaps all of us have benefited from not having an email account crash due to receipt of a large number of files. But both services they collect some information that one might not necessarily want shared, like how much time did you spend looking at that document? What time did you download it? What time did you download it as compared to what time was it available? How much time have you spent with respondents 57 as opposed to claimants 17? this information is all collected, but it doesn't really get any meaning until somebody tries to put it together to say, look, on a technological level, this arbitrator was paying more attention, was more attentive to claimant's case than to respondent's case, always opening everything within 30 minutes of receipt, looking at pages 1 through 17 for 2 hours, and then the rest just letting the computer idle. The computer's collecting that information. So, I mean, my way around it is simply when using either service, I download everything once, turn off the internet, and do all of my casework straight from the desktop computer, just to try to undermine any sort of information going out about how I actually process and open and read different documents. But it's creepy to me that that information is there, out there, collectible. I don't think it's protected by any kind of privilege. You've probably waived privacy to it somewhere in the terms and conditions too.
Hey, yeah, that's really a very big, very good point. Very creepy. And I vaguely remember reading somewhere about a challenge done before the Kenya courts against the co-arbitrator because he, when the tribunal made a procedural order based on some submissions that happened, they found the record that the co-arbitrator hadn't, quote, opened the document prior to the chairman's having sent the order. And so it was a question of whether there was a violation of due process. I would like to add the other one that is creepy is the whole thing of when you have all these electronic documents being submitted, the immediate effort apparently in law firms is to try to deconstruct the document to find the metadata, you know, where the changes are and all that stuff. And that whole issue of having to make sure you get the final that is the really final. And I don't know, making it a PDF and then copying it. And I don't know, all those kind of steps you're trying to go through so that all that process of figuring out what you're going to say will be not be sort of shown and who added what when in the particular document when it's a shared document. So that's another creepy area I don't have the answer to, but it's something that I think about, and I know that inside law firms particularly, or anybody, they you know, there are people who take care with that. Noam, do you have any you want to throw out with us, or could we'll go on to greater pathology?
The one I was thinking of was that Google sends me a map every month at the end of it, or they ask me whether I want a map of every place I've been. And they send it on Google Maps. You can see the routes you've taken. So it was, you know, it was amusing during COVID to see how, you know, I've hardly left my block in the first, you know, couple of months. And one road trip I took was, you see the whole US, and I mean, it's interesting. But how much of this data are they collecting? What are they doing? What are they piecing it together with in other ways, both to learn about me and to learn about sort of broader trends? That has creeped me out.
Yeah, good point. Excellent.
Yeah.
Excellent. So,
you know, I noticed today, back on Dropbox, I have several research assistants, and we also work using Dropbox. And I could see on there how much time each individual student had spent with different files open, because they, unlike me, work directly from Dropbox and don't just, you know, download it, make changes, and then put up a new copy. If I were a bad employer, I could be treating that like proof of attendance. You know, look, this says that you only had that document open for 5 hours. Therefore, you were only working for 5 hours. You're not even accounting for the other 3 or 6 hours that might have gone into, you know, other assigned research. People can use this as a shortcut.
Creepy. Everybody out there, I hope this feels a little creepy to you. If it doesn't, we can talk about that too when we get to the Q&A. So is it okay if I go to greater pathologies now? All right, so I'm going to go back and share screen again. Let's see if we go back there, and does it pop back to that thing? Start broadcast again, 2, 1, and then we go back up to share screen, and hopefully it will be where we are. Look at us. Okay, thank you, technology. We love you. All right, so that was great, lesser pathology. Let's go to greater pathology, and since I wrote this, it's obviously in small script, so it's a little hard to read, so I'll try to tell you the little stories. One of them that really has shocked me a lot is this Horizon scandal in England, when over 20 years, the various postmasters were sent to prison, or assistant postmasters, because the computer said they were stealing from the till. So there's this software that was taken that was used by the National Postal Service, and it turned out the software had a glitch in it, as of course the ones who made the software said it, or it worked as it did, that was saying that when, I guess, the postmasters did something or other, they were saying it was going basically out of the system into the postmaster's pocket. And there were people charged criminally with this. There was even one lady who was convicted on this who actually had a baby in prison, okay? And it turned out after 20 years of these things, they found out that in fact the software was not doing what it was supposed to do, and that all these people had been unfairly prosecuted. This reliance on quote unquote the computer told me is one of those things that really this case brings forward as to watching carefully about and being more vigilant about the so-called neutrality of the technology. A second one is what I call PreCrime AI, which is apparently, and there's a small Florida town where the police are doing some kind of algorithms adjusted by quote unquote experts in the police department to try to look at people who they think might commit a crime. In other words, they're not suspects. They're pre-suspect. They're just sort of bad characters or whatever the computer tells that they are. And what happens is that the police show up at these people's houses many times a day sometimes and basically harass them, even though they haven't committed a crime or even being a suspect in the crime. And, you know, the choice of who gets to be put into that box or not, it's not clear. One of the things that you sense when you read the articles in the paper about it is that what it's really about is trying to get those people to leave that town, okay? So it's not anything to do with sort of policing, but it has to do with really sort of changing the makeup of the town. Another kind of AI that I want to speak to is trying to find proxies for, or well, call proxies for race or gender. You know, I mean, just even a zip code will dictate a probability as to what is the racial composition of that particular area or where that person is from, and set up a probability. Maybe there might be in the manner of things that are bought that could suggest somebody's gender. I'm just throwing these things out. And anyway, using these kind of proxies, why that apparently have affected how lending is done to underserved communities. There's for example, there have been some cases with regards to car loans and lending for car loans where people of color, even with the same credit score, were charged higher interest rates, et cetera, gotten worse terms than white folks. And unfortunately, there is a strong effort to block disparate impact theory being used by, like, for example, the Consumer Financial Protection Board in its work, which of course means that you have to only see what's kind of intentional discrimination. And these AI things can set up situations of quote unquote neutral information that actually operate to discriminate as an effect. Another one is the black box algorithms. Black box meaning that the company sells it to the court and the court doesn't know what's inside this particular algorithm that's sold to courts that are used in pre-sentencing investigation. So somebody's been convicted of a crime and now they're trying to figure out the sentence. So they have a pre-sentencing investigation, PSI, and lo and behold, the computer gives a result that says that this person is really, really likely to be a recidivist as opposed to this other person based on something that the AI in the black box has said. Now, given that the AI is searching stuff that is across the society, to what extent is the AI just mirroring the societal bias, or is the old garbage in, garbage out? in its dictation of why this person's more likely to be a recidivist than that person, and even for the same crimes ending up with a higher punishment than somebody who's not from that particular group. And there have been some cases discussing this with regards to same offenders, same background, different race, large disparities. And this is not talking about judicial disparities, okay, which is a whole thing in itself, but rather about the pre-sentence investigation disparities leading up to effect of the judicial approach. I do know that, you know, different judges operate in different ways with regards to these recommendations. But one of the things you think about is also defense counsel, if I could say this, defense counsel who are looking at this pre-sentencing investigation and would like to know, how did you come up with that number 7, whatever that means, with regards to the likelihood of recidivism of this particular person, and wanting to get into the black box of the algorithm. And of course, under the contract with the court, that would, the company would say, oh, sorry, that's trade secrets and intellectual property. You can't see it. Well, how can you defend your client against a number if you can't see how the number was created? So there are efforts to have what are called white box algorithms, where literally you could figure it out on paper, the basis for where the number came from, so that the defense counsel and the prosecution too could argue about that and help in the judges and the determination of whatever is the sentence for the person. Another one that's a little creepy for me is actually more creepy for me is these cases that we've seen since the War on Terror, where the AI is quote unquote connecting the dots, and somebody gets put on a no-fly list, or something like that, and the question of whether those connected dots actually are reflecting something accurate, or it's just a false positive or false negative, depending on how you look at it. And of course, what is the process for somebody to get themselves off of the list? I mean, if it's a secret list, then you're not supposed to know you're on it. But if you don't get on a plane, you can suggest, that would suggest you might have a problem issue that you need. Then who do you contact to say, hi, excuse me? One of the things that there's a book out, I've forgotten the name of the emeritus Harvard Business School professor who wrote it, but it's called The Rise of the Age of Surveillance Capitalism. And it's a very interesting book from what I've read so far about the idea since the last 20 years or so of essentially with self-regulation and leaving technology kind of wide to go its own way without much control. It's turning into the market of capitalism is being changed dramatically. Another creepy one is in a book called Algorithms of Oppression by a woman named Sophia Noble, a professor out at UCLA, I believe, which is pointing out how Google searches will come up and reify societal biases in what they come up with. Like, for example, if you did a search for black girls, it went to porn. And if you went to do a search for white girls, it would go to, I don't know, dresses and things like that. And so why is that AI flipping that way as opposed to another? And what is it saying about the way the Google system is set up and the people who make adjustments on it, that those are the results that you get there? Last, of course, Facebook, or now Meta, I guess, algorithms that are humanly adjusted. This is kind of really creeping me out that they put in these, basically these weights, if you say. So if you put an angry face, it gets a higher weight than a bemused face. And that tends to cause the feed to come towards you with more stuff that gets your anger up. Remember, the goal apparently of Facebook, like any company for that matter, was for growth. It's a question of how much growth, and for profit, and the question of how much profit. And of course, that goes back to being quoted on Wall Street and what Wall Street was, right? But the point I'm just trying to make here is that in maximizing shareholder value, twisting sort of the feeds that each of us would get under Facebook or some other technology is something that's problematic. We can also speak about the kind of things that the Facebook papers have brought out with regards to the impact on teenage girls and things like that. But I'll stop there and now throw it to Katie. Katie, you have some greater pathologies you would like to speak about?
None yet. I mean, I'm sure we've all got interesting experiences on exactly that. Like one trick that I try to use to get away from, does Google, that I try to use to get away from the different Google algorithms is to regularly delete my cookies and then rerun the search. And it's always, it's amazing to me how much of a difference that makes. Like when I was working on the CETA list, when I started out, I wasn't getting very many responses from Google on women in international trade law. Every time I would put that into the search term, I would get pages and pages of organizations about women in international trade law, but not any actual women. Or I would get articles about how there aren't enough women in international trade law, but not any actual women. And but it was after researching for about 10 days that my Google results had done a complete flip. And if you were judging the world based on what Google was providing me, it looked like there was just a dearth of men in international trade. I could count about 4 men who routinely came up in my searches, and then otherwise there was a sea of about 320 women who were ready and able to accept appointments in international trade matters, 70 of whom eventually gave me their bios just for exactly that purpose. But, I could kind of see Google learning about what I wanted to be finding in my research, going from one day not being able to find a human female to 10 days in barely being able to find men.
Yeah, yeah, great, great. All right, let me go on to the next level in this little game. I hope people are enjoying it so far. So I will go to the back to the old presentation again. Let's see if it comes up. Yes, there we are. I hit the right button. Okay, so these are greater pathologies. And so then the question that I kind of got to as I get to the greater pathologies and sort of what I come to tricknology was this idea of algowrongs, okay? That sometimes these things can be so pathological that they are really algorithms, so trying to cover both algorithms and other kinds of structures of technology. I thought it was a nice little way to synthesize that idea. One of the algowrongs that I like to point out is cheap creep, which is like doing things on the cheap as opposed to doing them well in terms of the design that's there. Cheap creep may be related to the idea of what's your target market for whatever you're trying to provide and what they want, as opposed to maybe what should be more a broader vision of what should be wanted. And this is a problem for technology companies because they've got venture capitalists and angels and all that stuff that have their priorities. And remember, going public used to be something good, and sometimes, at least in the 90s, it was thought of that going public was the exit strategy for the company. So, anyway, the idea of cheap creep, which is not doing it well, or having such a targeted market that it ends up leaving out or excluding lots of potential users who will feel creeped out by the way the operation works. Another one that's really, I think, an algowrong is facial recognition software that does not recognize certain types of faces. This seemed to me it'd be like a 21st century version of they all look alike, okay? Because apparently there were facial recognition technologies that do not recognize black faces. And so this goes back to an old issue with Polaroid and other kind of Kodak film back in the days, which were normed based on white faces. They have a particular card that they normed it on. And the consequence is that whenever you took a photo with a Polaroid or Kodak film, the black people would always show up darker than they actually were. Another part of this. I've read an article recently that from somebody who pointed out that a lot of the facial recognition technology seems to be similar to what was in the 19th century called phrenology. For those of you who aren't up on your phrenology or didn't take that in school, that was the old thing where they would look at the shapes of heads to determine intelligence and, do those little things with calipers and all that. And of course, they had a hierarchy, and miracle of all miracles. Guess who was at the top of the hierarchy in terms of having the right kind of head? Gee, it was white people, then I think it was Asians, then I think it was Hispanics, then I think it was Native Americans, and then, of course, there were black people who were considered the least intelligent. Well, it's those kind of mind games that seem to be reproduced. But now, with technology, that in some of this facial recognition stuff, as this article said, and therefore we need to be more suspicious, prudent, hesitant, skeptical about these kinds of things. Remember, back in the 19th century, the people doing this wore white coats and looked really, really authoritarian and authoritative, maybe. And today, they might be wearing those pocket protectors, or maybe they are wearing white coats or blue coats and looking very authoritative too. But it still can be conceived as a mind game, or as some person once said, is that the ultimate error that is in these systems is that they think that the human mind operates just like a computer. That's a false one. Another algo wrong is the access device continuum. I can only think of 3. Most likely you'll think of more. Computers is one place, iPads is another, smartphones. I don't have a computer. I've been trying to teach a class on an iPad as opposed to a computer. I really resisted spending the money on a computer. So far, so good. Some of the things I want to do could be done on a smartphone. But what I'm trying to say is, what is the target interface, and what does that target include or exclude? In other words, there are a number of people in the world, and certainly in this country, who do not have computers or iPads, who just have smartphones as their access to technology. And does the particular technology really work for them? There are kids in high schools and all that. There are a large number of people who do not have Wi-Fi. And, the stories of kids sitting outside of, or actually even and students too, sitting outside of McDonald's to use the McDonald's Wi-Fi, or during the pandemic, bus drivers essentially operating to deliver food to kids as well as to be a Wi-Fi hotspot so they can do their homework. Shows the kinds of burdens that people can have to deal with in if they just have a smartphone. That's a further burden that's inside of that. So it's something that I think is an algo wrong and starts to look like technology. Now, another one is that if the data analyzed is based on background societal data, which has got inherent in it all kinds of biases that we all can see, what does the quote, the computer told me reify, I'm sure I wrote refit, my typo, reify, except as a quote unquote neutral reinforcement. Okay, I guess I wrote that all wrong. I'm sorry. But what I'm trying to ask is, when the computer says it told me this, what does that mean? Is the computer really this kind of neutral thing that is outside of us and is just telling us what the answer is, that's kind of done in a neutral manner? Of course not. We all know that the AI is not something separate from humans. AI is human. It's the human part that creates the AI and sends the computer on its merry way to do whatever with machine learning or whatever the particular technology term you want to use, to end up somewhere. And, one of the things is, of course, that the lack of any moral code in that process. So if you fit it wrong, you end up where you may not want to be. I'm not going to go as far as to say that we have the risk of Skynet, okay, all you folks who like the Terminators here. But I'm just trying to point to you that there is this, keeping in mind this aspect. So those are some algo wrongs as technology. My conclusion is that I have a T-shirt on that says no algo wrongs, or more broadly, I'm speaking to Leah Wing's point, which she said a year or two ago, I believe, that if there's no code, no justice is an important point to make. But I won't stop there. I'll turn to Katie again. Katie, do you have some algo wrongs you'd like to highlight?
You know what? Yes, I do. And if it's okay, I'm going to screen share a part from my presentation because it slides right in. On that point about the computer told me, what I've shared is a slide that has exactly that. People are eager to take the invitation from artificial intelligence and from computers to simply believe what is in them and to accept that there are not any biases, that somehow the computer is able to be less biased and more efficient than everybody else in the system. And I've put up this slide that says Arbitrator Intelligence helps secure arbitrators' release from prison. Once upon a time in 2019, there was an enormous corruption investigation involving bribes that were paid to several arbitrators. One of them allegedly a Professor Contrarius, who I talk about in my article. And he was put in prison pending the investigation of this scandal. And this is one that has implicated 4 prior presidents of Peru. It was supported by the company itself confessing to having paid bribes and co-arbitrators confessing to having received bribes and explaining how the bribes may have been papered over by excessive fees. That is why these arbitrators were in prison. And Katherine Rogers, the founder and CEO of a company called Arbitrator Intelligence, approached the Council of Ministers of Peru along with the International Bar Association and said that she was personally familiar with the case but had worked with the professor on projects related to artificial intelligence and to her company Arbitrator Intelligence. And I've underlined the text. The records in this platform show that he is generally considered by parties and lawyers as an excellent, highly efficient, and effective arbitrator. These are authorless statements made outside of court, completely unsworn. And what happened? He was released from prison for the remainder of the investigation. He had several freedom constraints, including not being allowed to leave his home country, but that the owner of a company was able to stand up and say, the records in my computer say that he's an excellent, highly efficient arbitrator, without being laughed out of court, should be, I think, very scary to all of us. It shows just how much trust people are willing to put into documents that say they're based in part on artificial intelligence.
That's a really great point, and I would like to if I can ask you to continue on with what we've discussed about the National Football League and the race norming stuff, which I think is really kind of an interesting kind of aspect of this too.
Yes, everyone, it is 2021, and the NFL has announced that it is going to stop race norming in its concussion settlements. What the NFL had been doing was applying one metric to black players and another metric to white players. The metric for black players assumed that the black players started their football careers with a significantly lower IQ than did the similarly situated white players. So they would assume, for example, that that a white player may have started with an IQ of, say, 120, and the black player started with an IQ of 90. Fast forward a few years, the players present their medical documents saying that they're suffering from dementia and that this is possibly related to concussions. The NFL would look through the papers and say, well, black player, this says that you've got an IQ of about 80, and really you only started the league with an IQ of about 90. This really isn't something that we're going to pay damages over. And the black players would walk away without compensation, whereas the white players, the NFL would receive the same diagnosis, the same IQ, and say, wow, well, that's a 40-point drop in your IQ, sir, and we are sorry to see that happen. Here is your portion of the concussion settlement. And for everyone involved in this, this is really terrifying that even today, people thought that it was okay to assign different intelligence standards to black people and to white people, to justify it based on science, and then to use it to determine who was going to receive part of the concussion settlement. And sadly, I mean, race norming happens all over the place. The NFL, fortunately, has admitted that the practice was going on and that it's going to stop. Congress, I understand, is also investigating how these racial metrics were used. But yeah, the computer told me, eh?
Excellent, 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 excellent. So I want to tell everyone that I will have to leave shortly because I mixed up my class times and I have a class starting in 10 minutes. So I turn it back to Noam. And Noam, what would you like us to do from now?
I'd like you to do whatever makes you happy. How about if we, I would suggest that if anybody has a question that or a comment that they feel would benefit from Ben's attention, why don't we give some time for that now? And then after Ben leaves, Catherine, you can decide the continuation of the session, or if you let everybody out early for lunch, but you get to decide how we go on.
Okay.
Oh gosh, I'm standing between everyone and lunch. Thanks.
No, I didn't. Oh, don't. My bad. We're in 100 different time zones here. Most of us have eaten already. So, comments, questions.
All right, so I have a quick question. It's a topic that's come up in an online discussion group that I lead in the New York County Lawyers Association called Mediators Meeting Online. We get together with mediators from all over the world over the course of about a month, and each month. And the question has come up with respect to diversity and the use of computer algorithms to select neutrals. Essentially, in court annex systems, what ends up happening is that you have an ADR coordinator or coordinators, if it's particularly complicated. And what they do is they get together, they screen the cases, then they decide based upon certain variables which neutrals to pick. Of course, now in New York and many other states, there's been a push for much more diversity in neutral selection. And one of the suggestions that's come up in the group, which I personally happen to find very interesting, is to use AI or machine learning to actually select neutrals and to take that sort of away from the coordinators so they can more manage the cases, in terms of the day-to-day operations, what's going on, if there are problems or other accommodations that have to be made. But the actual selection itself should be done by computers or, some sort of other technology or platform. And in that way, there might be a means of increasing diversity in the selection of neutrals in court annex systems. So What are the thoughts of the panelists on that?
Katherine, do you, or me?
Go for it.
Okay, all right. I'd say that, you know, if AI is something that can help, that's fine. But please always keep in mind that behind this magic AI is a human who's making the criteria to have the AI run that way. I think Catherine's little presentation about the search that she was doing for women changing over 10 days highlights some of this kind of impacts of how it's structured. Also, it's possible that you might, I don't know, I have not, and a computer person is going to be able to set, or a programmer, but I guess you can look for certain kinds of criteria that you think could be neutral, and hopefully that would generate a panel or a suggestion of people who would be panelists for it. I just, my only worry is whether the AI can do more than just help bring up a list of potential people, and whether that there would need to be some actual human evaluation of the person. I mean, another approach might be along these lines, which is kind of like with the courts, which is that with the use of the AI, you get your list, and then basically you use a random number generator, if I could say it like that, for who gets put into the place. There you don't have any bias of the particular case manager or person at that moment. You just have the next one on the list kind of thing. And that can have some advantages. I do want to say that I think this was a case on the National Arbitration Forum. You do run the risk that sometimes people will try to say that the person is quote unquote unavailable, so that it goes to the next person in the list. and then when somebody actually was available, the person that this was done to, I think, was now Senator Warren when she was a professor in law school. And that was part of her deposition in one of these cases. On that point, I really apologize, everybody, for my mix-up. I better go to this class because there's 95 students looking at me or expecting me to open a Zoom. So please bear with me and wish you all the best. And if anybody wants to ask me anything, please don't hesitate to send me an email at benspecialdavis@gmail.com. Or you can just Google me and you'll probably find me on the U Toledo Emeritus website. Okay. Thanks, Noam. All best to you, Dr. Simpson.
Thanks, Ben. Go. Don't keep students waiting. We're the strike of the time zones again.
There you go.
Get back into your own time zone, and we'll continue as we work.
My approach to that question is that obviously the market needs ways to be improving legitimacy in arbitration. And at the same time, the appointment of an arbitrator is one of the most important decisions that counsel is going to make in a case. What I would advise is that counsel do their best. As step one, do their best and make a list of 20 people who they believe could be arbitrators in a dispute. Now, unfortunately, if counsel is like the European Union and Canada, that list will end up being 100% white male. And at that point, counsel should really step back and say, gee whiz, here I was not expressly trying to find only Caucasians or only men, and yet my results have come up this way. How on earth did this level of racism and sexism creep into my search? And it creeps in different ways. Some of it is purely a researcher problem. We're all very smart researchers, and you skim past the names that might not match what you think or assume your clients or the case's needs are going to be. Maybe there's a part of the researcher that thinks, well, the co-arbitrators are all going to be male, and I don't think a woman could get a word in edgewise. Yeah, and these are all kind of mini prejudices that come out in full force when people are making lists of arbitrators. And so after that first step, you've got your list of 20. I would encourage you to search again, this time with the express goal of adding women and adding people of color, adding people who are living with disabilities, adding LGBTQ arbitrators. And I would encourage you to look at all of these groups, because what I found is that when the focus is only on women, Black men tend to get excluded. Imagine, I know I'm about to do air math, so this is not fun for either of us, I promise. You start with your 20, you think to yourself, I'm going to follow the equal representation and arbitration pledge, and I'm going to find 20 women that match. So, and as you're researching, you say to yourself, I can also be racially inclusive here. I can make my search come out to be 15% Black, just like the US Census, and still have 50% women. So on that, you would be looking for 6 African American women and 14 other women. It's great in theory, but in practice, it leaves this entire group excluded from consideration, which are diverse men. I think it's also important to check yourself and make sure that you are also including diverse men. Right now I'm working with the corollary initiative, which is having institutions and parties pledge that at least 30% of their roster will be diverse, racially, gender identity, gender preference, disability. And I hope that that will help make some progress, although it's not as much as 50%. It is 50% more than the American Arbitration Association defaults to when they're making their diversity measure. If parties don't request otherwise, they default to providing a roster that is 20% diverse, which sounds great in theory, but in practice they have they already have a background roster that is 30% diverse. So further subsidizing the white men at the AAA, I don't think is an effective approach to promoting diversity. But on top of that, social science research shows that if you have less than 30% of your proposed panel as diverse, that there is a 0% chance that that diverse neutral is going to be appointed. There might be tons of reasons for that, people assuming tokenism or assuming underqualifiedness. Whatever the reason, under 30% of a list means no diverse candidates are being appointed. Over 30%, that's where you start seeing a 50 or 60% likelihood that the diverse candidate is going to be chosen. So, I mean, for now at least, I think that 30% is a good magic number, and that one should always look over one's research and think, I did not intend for a result that was not racially diverse and was not gender diverse, yet this has happened. And to be deliberate in attempting to address and correct that, because there are hundreds of highly qualified, talented, say whatever word you want, arbitrators who are available for cases. And frankly, with all of the complaints that we've got about arbitration, that it's taking too long, it's too expensive, maybe somebody's corrupt, we couldn't understand the reasoning. What if all of that could be cured with diversity?
Thank you very much.
I think it's a nice idea. Thank
Now
you.
we just got to get computers to do all of
Okay,
that. Thank you very much.
Thank you. Well, now, yes, and I've got to figure out how to go back to sharing my screen, which I apologize. Am I still on here? Okay, here we go. Wait, and I'm still in the meeting. I accidentally clicked leave meeting instead of share screen, and it was all very, very scary. Whew. Very good. So, fake smarts. I wanted to call it fake smarts instead of artificial intelligence because I suppose that shows my views on it. I think that the name artificial intelligence generates so much credibility, but if you just break it down to what it is, fake smarts, it loses a little bit of its power. And it lost a bit of its power this week too, where I'm sure you saw in the last few days, Zillow became unglued. Now, I admit it took a few searches in order to get the top 5 results to tell exactly the story that would be what I was trying to say in this presentation. But it shows how you can manipulate the results that come back. And this is the picture worth 1,000 words. The sources are still a little bit out of order, but one at a time. Zillow tapped into artificial intelligence in order to create a system for valuing houses. And then it used artificial intelligence to create a robot for purchasing houses. And rather than buying low and selling high to flip houses, Zillow's robot was buying high and praying hard and losing $1.4 billion in what is currently still one of the hottest housing markets that's ever happened. And this is, that this company was able to trust artificial intelligence with $1.4 billion is startling on the one hand, and on the other hand, it says a lot for how much people are willing to trust artificial intelligence. I'm going to talk about fake smarts affecting real rights and opportunities, and this is based on a paper that I recently published with University of Toledo called Arbitrator Intelligence and the Mysterious Brown M&M. I'm going to talk about key information that is missing from arbitrator intelligence reports. I've already brought up one, the Contrarius report. I'm going to talk about how arbitrator intelligence reports can be used as vehicles for image manufacture. So you can build a reputation before you have a reputation. And I will also talk about, we've already talked about how we've already talked about race norming a little bit, but I think I will still close with that. So Arbitrator Intelligence, for those of you who don't know, is a private company that started out of a research initiative at Penn State Law. It aimed to increase transparency, accountability, and diversity in arbitrator selection. And it prepares reports on arbitrators. But you don't have to take my word for it. You can listen to Kluver Arbitration. Kluver, when you join Kluver Arbitration, you can also have access to Arbitrator Intelligence reports. It's a huge boost to their credibility in the market that these reports are also available through such a well-known and well-respected legal publisher. But I want us to look a little bit closely at this mini report that is on the page. Closely. Closelier. We're looking at the Arbitrator Intelligence report for Professor Fernando Contreras Salaverry. And what for me was the big tip-off that something might be wrong with this report is where I've put that little star in the corner. I don't speak Spanish, but I do know that that is not how you spell Universidad de Pacifico. It's Del Pacifico. It's just a little typo, but it indicated to me that maybe something else is also missing from this report, like an Eminem backstage at a Van Halen concert. Now, what's missing from this page, and I've already spoken about it, is any reference to the fact that this arbitrator was under investigation in the largest corruption scandal to sweep international arbitration. And it's not that he was under investigation years and years ago. He was under investigation simultaneously with his profile being used as the flagship report for Arbitrator Intelligence. Now, I find this particularly troubling because, in a way, well, whether your arbitrator has been accused of receiving bribes in connection with an arbitration would be relevant information that counsel might want to consider when making the decision on who to appoint or who to put on one of those lists. In this report, that is nowhere to be found, even though the founder and CEO of Arbitrator Intelligence was very aware of this event, so much so that her statements helped secure his release from prison for that exact issue. But another space where Arbitrator Intelligence is making waves is in reputation manufacture. Here we're looking at the profile for Professor Roque Caivano, who is this profile is also used in Arbitrator Intelligence's advertising. And I've put some stars on the interesting points where Arbitrator Intelligence tells the world that this professor has served as arbitrator in an ad hoc ICSID arbitration seated in Washington, D.C. Reading that, you might think, I don't know that you can have an ad hoc procedure governed by the ICSID rules. Something doesn't sound right there, and I don't know that you can have an ICSID proceeding that is legally seated within another country. It sort of goes around the whole equality of states issue that we see come up in investor-state arbitration. But what really got me, and I was so happy that they highlighted it in their advertising, was that this says that that this particular arbitration was a fast-track arbitration. Fast-track arbitration invented by Professor Ben Davis, who is not here to hear the shout-out, but it has been made. It says that he was arbitrator in a fast-track ICSID ad hoc arbitration. All of these together, if you're reading quickly, make for a very interesting candidate for a proceeding. He, according to this piece of paper, has experiences in cases ranging from $10 to almost $200 million across different institutions. Nobody ever requested document production, so the report can't say anything about that. But it seems that he has a lot of really valuable experience. So you turn to Arbitrator Intelligence's instructions for how to read its report. And what you see is that, well, I think it's at star 3. Arbitrator Intelligence is not currently able to systematically and independently verify all of the data provided to it by AIQ responders. As my 5-year-old would say, hubba what? Another, questions that responders left blank or answered in the negative are generally excluded from this report. This is guaranteed to be a happy report. And at the bottom, the arbitrator has consented to the publication of this report, which, I mean, juxtaposed against the other statement that this published report used in their advertising is simply a confidential draft not for circulation or duplication. You know, you take typos as you find them, but it says that the arbitrator has consented to this report. What I see here is a venue for people to create reputations in arbitration in order that they can begin getting cases in international arbitration. So what does one do in the face of this, of a report with unverifiable information and basically without an author? Well, you can look and see if you can duplicate it. Part of research is seeing whether you can duplicate findings. And so my first stop was to go look at ICSID. Say, well, I do not have ICSID memorized. Maybe he has done an ICSID case. But what the ICSID website tells me, in their list of everyone with his particular citizenship who has ever been appointed to a case or has been nominated to one of the panels, is that this individual has not done an ICSID case. So trust but verify. Here the verification failed, ergo perhaps the Arbitrator Intelligence report is not to be trusted. You can also look further. The ICC will tell you who has done their cases. And they will share that he was president of a tribunal, but was appointed by co-arbitrators and not by the institution itself. And of course, for further information, one can always reach out to the institutions and to the individual to get the original data and to get the original information that you're going to be using to make your decision on who to appoint. But I want to close with the idea of, in this field, you are either the purchaser or you're the product. And I try to keep this idea in mind whenever I'm looking at free information. If it's free, chances are I'm the product. I'm the person who's reading the Arbitrator Intelligence reports and developing an idea that somebody might or might not be credible. To the individual arbitrator, I'm just a market. And I mean, with that, I would, well, another point that was picked out, which I should have discussed when Ben was on, this company is enabling people to make reputations very quickly. And one way that it is doing that is in its pricing. reports, the report prices change a lot. And when I wrote my paper, the pricing was between $500 and $20,000 for a report. But interestingly, all of the arbitrators of African descent, regardless of case experience or seniority, were each priced at the lowest possible rate of $500. And if I had had the word race norming in my vocabulary at that moment, I would have used it. Because even in later publications, Arbitrator Intelligence explained that it was trying to market African arbitrators for the markets in which they exist. And this idea that African arbitrators only exist in one continent or in one income sub-bracket was able to be broadened into a pricing metric that made them all appear to be the least expensive in a price equals prestige market. In arbitration, you don't want to be the cheapest arbitrator, you want to be the best arbitrator. And they used a pricing metric that relegated every arbitrator of African descent into being the cheapest arbitrator. So with that, I will close for discussion and questions, and thank you for your attendance. Well,
I wouldn't be surprised if everyone is just so unsettled from what you and Tim have shared that many are going out and erasing their Amazon history list and such like, so that they don't wind up appointing the wrong arbitrator. Folks, open floor. Anybody want to weigh in with questions or comments? This is all this interesting juxtaposition between this and ODR, of course, and our day-to-day lives in which we are all, we encounter the smaller pathological technologies and sometimes the greater, not in our personal as well as our professional lives. So this pertains to everything and everyone.
I think a few years ago, you'd look at self-authored advertising with intense skepticism. And of course, attorney advertising is subject to its own rules, but how much can you really trust what an individual is putting out there about themselves? But now, it seems in many cases, it seems that is the more trustworthy information, because at least it has an author who can be asked about why did you put that in there. And with different AI services, you don't have an author, and so you don't have accountability. There are some arbitrator profile areas that have accountability. Global Arbitration Review's arbitrator research tool. All of the information is authored by the individual arbitrators, so the individual arbitrators are actually accountable for what is stated there. That's a good place to start in one's research.
Not so much a question, just maybe a tip in terms of verifying information. AAA and many of the other, large ADR providers require that an arbitrator in his or her resume that's officially submitted verify the accuracy of any of the representations contained therein. So one way of perhaps gauging the veracity of reports from outside sources like Arbitrator Intelligence that was discussed, very interesting, by the way, thank you, against other, those other things of what the arbitrator really did, you may be able to compare that particular arbitrator's resume, cross-check it, in much as what was done in this particular case with the ICC, as he was being used to cross-check, but have the arbitrator submit back his or her resume with one of those organizations that basically will penalize him or her for inaccurate statements, including but not limited to removal from the rosters. And by doing that, you can figure out whether or not what you're getting is the real McCoy.
Yes. Sometimes more information is helpful.
I wondered about that myself in a different way. My children have been showing me recently on YouTube things like Harry Potter only written by an AI. So you have AI generated texts of Harry Potter books. They fed all of the Harry Potter texts into an AI and asked it to spout out another story. And you can obviously tell that it's written by an AI, and there are of course hilarious moments, but it made me wonder sort of how much data would need to be in there until it wouldn't be hilarious anymore, and until it would start to approach J.K. Rowling, and in the end, it's going to be a lot quicker than having an infinite number of monkeys for an infinite amount of time. And thinking about that, and Elon's comment, and also flipping this towards the ODR, as we're not only using technology or sort of customers using technology, as we've been thinking through much of this session, we're dealing with and also dealing technology. In other words, we are not only authoring these texts that go into the computer systems, we are also designing, whether we are active, computer program designers, which I am not, or giving input to the folks who are designing these systems, which many on this call are. And it just reminds me how easy it is to unintentionally be part of the problem. And I know that wasn't the focus of this session, but that's sort of, as the session went along, that has weighed on me increasingly. I know you try to fix the world, and you wind up doing something that could really make things worse. And of course, being mindful of that is so important. But I wonder if you can ever be mindful enough. I don't know where I'm going with this.
No, you're at the law of unintended consequences, and you're also at a very key part of all of this, which is the user. And whatever items Google spits out in response to a search, that's just one part of research. The terms that I, as the researcher, chose to use is part of it. But then the other part is how I chose to read and appreciate the results. And the problem of people skimming in the arbitrator search context, skimming past names and faces that don't match what one is expecting from an arbitrator. And it's such a pervasive problem. And when I was creating the Arbitrators of African Descent roster, I ran into it, just that many arbitrators of African descent do not have photos of themselves online, because they want to get through on their CV and not give the reader a chance to skim past once they see race. I often wish that I had a two-way name, as Frances Kelsey Oldham, who in the United States was the founder, the real first boss at the Food and Drug Administration. She only got to do her PhD because the admissions committee thought that Frances was a boy. And she turned the FDA into the organization that is presently saving many lives across the country. Yes.
1 minute comments. Just last thoughts, folks. We're almost at time.
Okay, well,
think of your last
I think the class has been good. We could let them go.
Okay, so let me wrap this up by saying whoa, and thank you, Catherine, and thank you to Ben, who maybe you'll watch this recording again and hear that we thank you. This has been wonderful, and I'm so glad that we have this line of thought deeply embedded in ODR and its development, both for cautionary reasons and also for reasons of, hey, how can we figure this out and do better in the world? Piggybacking off myself, Ben isn't the only one who can watch the recording. This session was recorded. It will be up on the and linked to in Cyberweek's agenda. Cyberweek's agenda, which includes sessions from for today, the rest of the day, and tomorrow. I've put it in the chat. It's available. You can find the videos there. You can find them and on my YouTube as well, and some of them on arbitrate.com as well. So you can continue to spread. If you found this to be an interesting session, you can share it with others via the videos. I'd like to invite you all to continue in the sessions that are going to be in the rest of the day. There's a social hour this evening, which you are all very invited to. And I hope that we'll all be able to meet new people and to carry out that promise of accessibility that I opened up with today. So thank you all for coming. Thank you, Catherine. Thank you, Ben.
Thank you.
Happy Cyber Week.